Welcome. 4SA, Liesl, Michael.
Thank you.
It's so cool to have you guys sitting in the studio with me. And for those that don't know, this is Vaughan, the Cyber Hitchhiker on my digital platforms. But today's not about me. It's not about anyone else. This is to tackle really the hate speech bill, which and that's why I'm so grateful you guys came in, because I've had so many people going, but Vaughan, we don't even know what to say anymore. We don't know where the boundaries are. We don't know what the hate speech entails. We have no clue now, and especially from the religious sector. They are very scared about what they can and can't even say just in a casual conversation. I work with digital media, so I've been talking about what you can and can't say online in your written texts and digital posts for a very long time, even before the hate speech bill came out. But it's very different now that we've got this bill passed into law, and a lot of people are very intimidated by it and are very scared to put stuff out on audio and to put stuff out on video now. So thank you guys for coming, and let's get right into it because we don't want to waste any of our guys' time. So let's start with Michael. Give us first, before we start, do any questions. I always like to do this just in 2 minutes. Who you are. I'm pretty sure most people know who you are in South Africa anyway, but who you are, where do you come from, and what are you doing now, and Liesl for you as well.
Well, I'm originally from the UK, so I came to South Africa in 1983, and I had an interesting career mostly in the Christian ministry world. I was one of the founders of the His People Every Nation churches.
Okay, wow.
But I've also had business interests, and I've been in America with Every Nation internationally. And lately, the last 8 years, I have been fully focused on freedom of religion in South Africa, where I have the privilege to serve as the executive director in the fight for faith and freedom.
Okay, wow. So what is, for those that don't know, Freedom of Religion South Africa? Who are you guys?
So we are a legal advocacy organisation. So we specifically defend our constitutional right in Section 15 particularly, but also there are many other expressions, of course, of religion that are protected also in the Constitution and in other law, to defend and promote our right to religious freedom, which is a basket of human rights. It really is the foundation stone, because it is not just what you believe, it's your conscience, your thought, your belief, your opinion, and your religion. So it's very much the foundation of all democratic rights, because it includes things like freedom of association, freedom of assembly. Very importantly, parental rights, your right as a parent to pass on your views, your values, and your beliefs to your children. So it's broad-based in one sense and narrow in another, but that's what we exist to do. We are, as we say, the defenders of faith and freedom.
Right, and for those that don't know and might get the wrong idea, 4SA is all religions. It's
Yes.
freedom of religious expression across all religions in South Africa.
Precisely, yeah. We defend the faith of all faiths because, again, if we want to have whatever faith you particularly want to believe in protected, then you need to understand that this is a generic law. It's a generic right. And it also, of course, is a politically neutral basis. So we don't have any particular political bent. We work and look to work with any political party, any political actor who is also willing to protect and promote and to understand maybe the critical significance of religious freedom. And of course, in terms of faith, we are faith neutral, and we're also doctrinally neutral. So we believe that you should be able to believe whatever you want, or not believe anything at all for that matter. So it is, in that sense, a very generic right, but a very critical foundational right to any democracy worthy of the name.
That is, it is so awesome to hear someone say that, because you don't often get someone who can say we are not biased in any way towards anyone or anyone else. We're all inclusive of all religions, and we will defend and protect and advocate for anyone, especially when it comes to religious freedoms in South Africa.
Yeah, and we work with all different faith groupings. So we work across a broad spectrum. Everything, obviously Christian faith, but also African traditional spirituality faith, Islamic faith groupings. We recently represented some 20 million people from those different faith groupings when we went and met with the DBE. So it is a significant coalition, if you like. And people are increasingly, I think, concerned that their right to faith is being eroded by laws and other things.
Yes, and that's why we're here today. But before we get into the hate speech bill, Liesl, let's not forget about you. We met in a panel discussion the other night, and that was absolutely awesome. But today is a different topic altogether. Who you are, what do you do at 4SA?
So I'm Liesl Pretorius. I'm the head of legal at 4SA. I joined 4SA at the beginning of last year. Before that, I was involved for about, I don't know how many, 5 years or so, in another organization broadly looking at human rights, constitutional rights. And before that, I was a practicing attorney. I'm still an admitted attorney, non-practicing. And I'm also a wife and a mum. And I enjoy working in this field of work. I think, as Michael has said, this is such an important foundational right in South Africa, really important for our democracy, and really important for persons of faith. I'm a person of faith myself. So it's an honor and a privilege to do the work that I do.
Excellent stuff. Right. So without further ado, guys, we're going to get into the meat of our discussion today, and that is dissecting the hate speech bill in the shortest amount of time possible without skipping over anything. So let's start with you, Michael. Where does the Hate Speech Act come from? And I'm sure everyone wants to know this. Whose idea was it anyway?
Well, it's actually quite an extraordinary development because there was a move which goes back many years to codify all the law concerning, let's say, hate crimes. In other words, where you have a crime that's got an element of hatred that really exacerbates it. And nobody had a problem with that. But then in about, I think it was 2019, Deputy Minister John Jeffrey in the Department of Justice suddenly introduced the hate speech component. And of course, that's a very different kettle of fish. We've never had a problem from the beginning with the codification of hate crimes. But hate speech is very, very chilling. You mentioned right off the bat when you were introducing the program how people are scared of putting up something on their website or podcast or whatever it may be. And one of the critical issues about, let's say, which is this does, criminalizing something that you say or express, is that it literally causes people to self-censor. You almost put a gag on yourself. And never mind that you might never ever be prosecuted, but the fact that there's a danger that you might be causes you to self-censor. And that is very unhealthy, because the essence of a democracy is that we have robust debate, that
Correct.
We have different viewpoints, that we might have wildly different viewpoints, but somehow in the midst of free and open discussion, one will prevail or compromises are reached, and that's how our democracy historically has evolved. So this was a very, let's say, dangerous departure from the norm. It is unfortunately something of a global trend, but typically what the Hate Speech Act does is it goes far beyond what is constitutionally, let's say, unprotected. So all speech in South Africa is essentially allowed, except speech that amounts to hate speech. And as we're going to get into in the course of this discussion, the devil is in the definition.
Yes, correct. Correct.
And the question is, when is hate speech, which nobody would support legitimate hate speech,
Correct.
When does that verge into just simply speech that I hate?
That brings me to the next question. So you said it yourself. What is the difference between real hate speech and speech that we hate?
Well, again, back to the Constitution. The Constitution protects, let's say, all speech except for hate speech. And hate speech is defined, among other things, it's got some definitions that really won't apply, like if you advocate propaganda for war, for example.
Correct.
But that's not really what we're talking about.
Incitement to violence.
Yes, but what we're talking about here is an advocacy to hatred. This is what the Constitution says you cannot do. You cannot have an advocacy to hatred combined with an incitement to do harm. Those two should run together. And so a typical hate speech, in my view, would be something like gas the Jews. Who do we want you to hate? Jewish people. What do we want you to do to them? Gas them.
Correct.
I mean, that's pretty clear in my...
Yes.
But that's narrow. That's subjective. You can pretty see who the hateful group would be and what violence we want to do to them.
Correct.
The danger comes when you start to blur the lines, when it starts to become subjective. And of course, the more subjective it is, the more open to, let's say, opinion it is, the more it starts to merge towards, well, I just find that deeply offensive.
Yes.
Then that's where you start to have problems, because then you don't have an objective standard. Then you can't really know, is what I'm saying hate speech or is it not?
Yeah.
Because the subjectivity kicks in.
Yeah, that's the scary one for me, is this whole opinion thing. The way someone's going to take something that you say, even if you're not meaning it in the way that it's supposed to be meant, that person might take it in the wrong way, and that's where I think this whole blurriness comes into it. But Liesl, you are head of legal. What is the justification, or supposed justification, for the Hate Speech Act, and let's say according to their promoters anyway?
So when the Department of Justice released the original draft bill for comment, it said that the purpose of this bill is to give effect to the Republic's obligations in terms of the Constitution and in terms of international human rights law. For example, a big international, very relevant treaty is the International Convention concerning combating racism, racial discrimination, xenophobia, related intolerance, ICIRD for short. What is interesting is that we ratified ICIRD in 1998. This draft bill was open for comment in 2016. What happened in the meanwhile? And of course, we don't have only one international law obligation. And as Michael said, nobody is condoning true hate speech.
Yeah,
we
definitely.
certainly are not. We have respect for all people and they value their inherent human dignity. But we also have international obligations to protect freedom of expression. And in terms of these obligations, we know that the limitation on freedom of expression is very narrow, and for a very important reason. It is a critical right for democracy. It is a foundational right to other democratic rights. And also that's why our Constitution has a very narrow limitation on what is unprotected speech. So that's the justification. We don't necessarily agree with the justification or the way in which it is being done, or has been done, is the best way to address it. But that was the reason given.
Right, so go on from that, and let's have a brief sort of journey or story of how this whole thing went through Parliament, because the hate speech bill didn't pop out of nowhere. This has been happening over years and years and years. We've been hearing about this bubbling over. How did this happen? How did this journey happen through Parliament with the hate speech bill?
It's quite a long journey. So
Yes.
a draft bill is when a bill is still before government department, then it gets introduced in Parliament. It was introduced in Parliament in April 2018. And then in the National Assembly, which is the first house, then it goes to Portfolio Committee. They're supposed to process the bill. The bill was in that Portfolio Committee between 2018 and I think until March 2023. That's quite long.
Yeah.
So in that they have public participation processes. The government department, the Department of Justice will come and brief the committee on the bill. One of the big reasons why there was this big pause was there's a very significant Constitutional Court judgment, Quilani, which is the locus classicus on hate speech. And they were waiting for that judgment to be delivered because it would have a profound impact on what the definition of hate speech should be. Even though Quilani, this is a very important distinction, concerns civil hate speech. It concerns the Equality Act. The full name is the Promotion of Equality and Prevention of Unfair Discrimination Act, but that's why it was held over. Then eventually the bill was passed by the National Assembly in March 2023. Then it moved over to the National Council of Provinces. The second house also had public participation. They eventually passed the bill in November 2023 with some amendments. So the National Assembly quickly had to look again at those amendments. So this is quite a long journey for a bill, but it was passed by Parliament, the whole Parliament, both houses, on 5 December 2023. Then it went to the President's desk, lay on his desk for a couple of months, and President Ramaphosa signed it into law on the 6th of May this year.
Yes, which made my editing life very difficult for our panel discussion, because he signed it the day after we had that Thursday night session. And I had to edit myself out with a lot of stuff that I was saying, because I was scared that I was going to get into trouble. Everyone else seemed to be okay. Liesl, you were fine, because you always say the right things, being a legal person. But that's for us, say, in general. You guys are always just saying what needs to be said. You don't sort of lean or try and put anything in there that's not supposed to be in there. That's why it's so cool having discussions with you guys. So, Michael, getting back to you, for how long And in which ways? Because this, for me, I only really started hearing about 4SA when the hate speech bill got brought up the first time many, many years ago. How many ways have you guys been involved with this? And with the Department of Justice to Parliament to the President, all of these things, 4SA has been involved with all of this for a very long time, since the beginning. For exactly how long and in which ways?
Well, the first thing we always do when any law comes out, and the hate speech bill, now Act, is no exception, is that we look at legislation or regulation, whatever it may be, and we analyse it to see what is the level of threat that we perceive that it will have on our right to religious freedom and other related rights. And of course, this was a big one, because here you have not only a law that is very broad and far broader in its definitions as we saw it than even the Equality Act, never mind the Constitution, but it also criminalises hate speech. In other words, this isn't just the difference between a civil case under equality and the Hate Speech Act is that under a civil action you can be forced to pay a fine, or you can be forced to make an apology, or whatever it may happen to be, but it doesn't put you in jail. This obviously has a jail sentence which initially was 3 years, so that was the initial proposal. 3 years for a first offence, I think 5 years for a second offence. And so we mobilised. We obviously then try to inform people. We try to make it simple to understand, and then we inform the public, which is typically the faith community in particular. That's who we are obviously working for. And there was a predictable high level of concern. And their first public participation, I'm not sure exactly, these will remind me, but I think it was about something in the region of sort of 15,000, 17,000 submissions were made, because that's what happens. You're invited to make a submission, which is typically a written submission, where you give your reasons why you're concerned, and hopefully you are more constructive than that. You propose alternatives, or you at least explain why you're concerned. But that made very little difference. The only thing that did happen was that there was a very, let's say, weak defence added in for bona fide religious expression, which we immediately said was inadequate, simply because, as Liesl can explain a bit later, it really doesn't provide a defence at all. It kind of means that what you're saying, if you're saying a religious expression that's hate speech, is protected as long as it doesn't amount to hate speech according to the definitions of the bill. It's like that,
Sure.
That's not really a defence at all.
Yeah.
But it progressed, and it went to the National Assembly, and then we had more rounds of public participation. And the second round, there was a major pushback. I think something in the region of 100,000 people wrote in and actually made submissions and pushed back against it. And again, the remarkable and bizarre outcome of that was that the 3-year jail sentence was increased to 8 years.
It went up and not down.
Which gives you a sense of how arbitrary these things can be. And then we went to the NCOP. There was another round of public participation. And again, I'm not sure of the exact number, but I think it was around, 50,000 or something thereabouts. So a big pushback again. I think most people thought that they'd already had their say. So I think people were a bit slower off the mark third time round. But nevertheless, so in total, we had over, and then when it went to the president's desk, there was another nearly 10,000 people who wrote to the president and said, please don't sign this, for various very good reasons. Its unconstitutionality, the vagueness of the definitions, the fact that it's basically anti-democratic and in breach of international. There were many good reasons, which Liesl can unpack. But the bottom line is that for, we think, very bad reasons, that public participation was ignored, and the bill was then signed into law. So, long process, a lot of public participation, but the question is, and this could well be a very powerful next step, is did government give meaningful, and the emphasis on the word meaningful, public participation? And of course, if you simply ignore everything that the public are telling you, is that truly meaningful? Are you not just simply trying to tick a box and just move right along? And if you do that, potentially, that is something which is unlawful and unconstitutional, and therefore can be grounds to challenge it. And we'll see where that goes.
Yeah, and you preempted what I was going to ask about public participation, because it often seems that it's just a box that is ticked and doesn't really make too much of a difference. And I didn't know that you could actually take a legal recourse on that. So I'm very happy to have learned something new today regarding public participation. I think a lot of people don't even understand that. So that's a good thing.
It is, I think. I mean, I've called it before the golden key. Because a lot of people think that when it comes to, public participation, it's basically May the 29th. We all go, we stand in queue, we tick the boxes.
Yes.
Somebody gets into Parliament, we hope for the best, we get the worst sometimes. and then we sort of wait another 5 years and we have another crack. But that is not how our constitution sets up our democratic lawmaking process. Every single time government wants to pass any law or policy or even sometimes regulations coming out of the executive, they have to put them out for public comment. In other words, they have to give the people the opportunity to have a say, to at least know what's going to happen before it happens. That is something which government has known forever. That is something which I think most people aren't aware of at all.
Yeah.
And one of the things that government loves to do is it publishes it in something called the Government Gazette.
Yes,
I've asked people randomly, how many people have ever read the Government Gazette? It's fractional. We read it every day. And so what is happening recently, and we think this is a very positive democratic development, is that organisations like ourselves are watching like a hawk. Because sometimes government will put something through that they really don't want anybody to worry about on, say, the 15th of December.
When everyone's going on holiday. Yeah.
And then they'll close the comments on the 15th of January. So you come back from with your suntan to find that some horrendous law is now kind of like heading your way.
Yeah, sure.
But we watch this, we push back against it. And that is very significant because there have been constitutional court decisions which have basically already said that this is indeed a very powerful and even essential democratic right. Yeah. Government can't just tick boxes. They can't just ignore the public. They must actually always in a democracy be responsive to the will of the people at all times. They must be listening.
Yeah.
And of course, as we are seeing, and I think we've seen particularly in this case, government hasn't listened at all. And so the outcome of that we think could be very significant.
Yeah, it definitely seems like the government hasn't listened at all. So, Liesl, getting back to you, were there any positive moments or developments? Some MPs who did take the concern seriously, a significant number of public responses, which we have discussed a little bit, and collaboration with other free speech defenders.
Yes, I must say, I mean, it's quite a grim picture. And I think overall it is quite a grim picture, but there were positive moments. I'm glad to say there were MPs who took our concerns seriously. Like we have said before, we are willing to work with any political party who's willing to give us an ear, who's concerned about upholding freedom of religion. And they were. Unfortunately, the way that these committees work is it depends on who gets the majority of votes when the decision is made in the committee, because it's voted on. Do we want this amendment to the bill? Don't we want this amendment? So if you don't get enough MPs standing for what the amendments that we're pushing for, it goes through. And that's problematic. So that's why it's important to vote to vote according to your values.
Yes, that's a big one.
Those people will sit in those committees. But we are so grateful for MPs who do take those concerns and do take strong positions, and often they're in the minority, but they are that voice speaking up. And we're also very grateful for the significant public participation. As Michael said, in the second house it was less, but probably because people, they didn't necessarily understand how public participation worked, but we've already commented and they don't know this is a new public participation process. But we are grateful on some other bills, when we're talking about the Hate Speech Act, but on some other bills we've had significant public participation. It has really made a significant impact. So we were grateful for that, and we work with like-minded organizations who stand for freedom and democracy, and it's always good to be able to do that, to have those working relationships and say, are there things that we can agree upon? Can we exchange ideas? What can we do? Because you can't just be one voice for freedom.
Yeah, correct.
It's good to have a broader spectrum of people coming together, and because that should have significant weight. If you have a lot of stakeholders showing up and say, please insert a definition for hatred, and the public says, please insert a definition for hatred, that should have a significant impact.
Yeah.
Unfortunately, it didn't. But it gives, something later down the line, if you want to perhaps bring a challenge to a bill like this, to say that, there was the public participation meaningful? Did people actually pay attention to what was being said? But yeah, so even if it's an overall grim picture, I think there were good developments, and it's good to work together. It's good that the public responded as they did.
Yeah, it's so important. I think you guys have hit the nail on the head, because you often get a lot of pocket groups that are not working together or don't sort of know each other. And if they just all came together and networked and worked together, the kind of impact that would have, because now it's a broad base of people. It's not sort of just a specific ethnic, religious or cultural group, but it's multicultural, multi-ethical, multi-religious, if I can say that, and put it together, it creates an impact, because a lot more eyes, or like we like to call in digital marketing, a lot more eyes are on your brand or on what you're trying to convey to the public. So this is a big one for me. Freedom of religion, and how is it connected to freedom of expression, and then other fundamental rights, dignity, equality. It's a little bit because I think this is what the religious community is worried about the most. It's, are we allowed to freely speak what we believe and express our faith in a way that's going to be okay, without infringing on anyone's dignity or equality? And how does that relate back to the hate speech bill? It's like...
Okay, so let's just go. It's going to be a little quick lesson, high-level lesson in constitutional law. So, freedom of religion is protected under Section 15 of the Constitution. It's a broad right. It includes freedom of conscience, religion, thought, belief, and opinion. So that's why people often don't get that. It protects all worldviews. Even if you're atheist or agnostic, you're protected under freedom of religion. It's not just traditional religion. Very broad right. Now, freedom of expression, also a broad right. You have specifically protected expressions, press and the media, obviously very important for democracy. Freedom to receive and impart information and ideas. That's an important one.
Yes.
Also artistic creativity and freedom of academia and scientific research, etc. But freedom of expression has an internal limitation. And the limitation is freedom of expression does not extend to propaganda for war, incitement of imminent violence, and hate speech, which the Constitution defines as the advocacy of hatred that is based on race, ethnicity, gender, or religion, and that constitutes incitement to cause harm. It has to also not only be hateful based on those grounds, but also incitement to cause harm. So how is freedom of expression and freedom of religion related? Well, the right to freedom of religion is... there includes the right to manifest your religion, your beliefs openly, in private, but importantly in public, without fear of hindrance or sanction from the state or anyone else. You can do it for observance and practice. It's not someone recently said religion it's personal, but it's not private. You are able to speak out and live out your religion. South Africa is not a secular state. It is faith neutral, or worldview neutral, but it is not a secular state. Religion is welcome in the public sphere. If you look at the second section of Section 15 of the Constitution, which protects freedom of religion, it says, religious observances may be conducted at state or state-aided institutions. It's welcome. It's not the strict separation. You're allowed to have prayer in school as long as it's subject to certain rules. It's equitable, it's free and voluntary.
That's crazy.
That's important.
A lot of people think that it's not allowed. You are not allowed to express your religious freedoms in school anymore. If whether you across any religious group, whether you're a Christian, you want to pray, whether you're Muslim and you want to pray, whether you're Hindu and you want to pray, it's often looked at now, because I speak to a lot of parents and a lot of homeschoolers specifically, and this is the thing. It's like, am I allowed to even express my religion in public and pray publicly? Or if I'm not talking about whether you're Christian or not, I'm talking about just religious expression. Whether you're a Muslim company, a Christian company, a Hindu company, a secular company, if you want to get your guys together and have a quick moment of meditation, prayer, evoke a scripture or whatever, a lot of guys think that you can't do that anymore because someone is going to get offended and you are going to get into serious trouble. It's really, really crazy. So that, what you've just said now is actually quite shocking to me, because I didn't realize that it wasn't illegal. The way everyone acts is like, this is already illegal, guys. You're not allowed to do this.
This is why important, sorry, Michael, to know your rights.
Yeah.
To have religious observances in schools, subject to rules that it's equitable, free and voluntary, that's protected in Section 7 of the Schools Act. It's specifically there. So parents, this is a public service announcement.
Yes.
Religion is allowed in schools.
And very importantly, there was a case in the Johannesburg High Court where a group with the acronym OGOD, an atheist group, brought a case to basically say against some schools to say that 70 plus religious observances should be banned from schools. They claimed this was freedom of religion. Of course, it wasn't. It was freedom from religion.
Yes.
And we 4SA were an amicus, a friend of the court in that case. And the good news is that the unanimous decision of that High Court, which is then binding obviously on all lower courts and obviously in the Johannesburg area at a High Court level, but pretty much because it wasn't appealed is the settled law of the land, was that the responsible body who gets to set what religious observances can or cannot happen is the school governing body.
Yes.
And the school governing body is very powerful in that instance because they have the power to set a religious policy. Now, there are certain parameters to that. It must obviously reflect the religious basis of the learners of that school, and therefore it's dynamic. It doesn't have to be one day Muslim, one day Christian, one day this, one day that. It's overall reflective. But it means that they can allow all kinds of religious observances into the school. You can still have pastors speaking at the school assembly, or prayer on sports day, or carols by candlelight, or something like that. You obviously mustn't in any way make other faith groups feel uncomfortable,
correct.
And it's always going to be free and voluntary. You don't have to attend. But within those confines, if you like, then yes, and it is not like America. And that was exactly what this case was trying to establish, was they wanted South Africa to be like America, where like never the twain shall meet. Not the case in South Africa. And parents should understand that, and schools should understand that, and religious leaders should understand that. Because that door is open.
Okay, that is like, I know that there's going to be a lot of wow moments when people hear that, because a lot of people have been, whether it's through misleading people saying things in the media and stuff, you sort of just sit back and go, oh, but this is not allowed anymore, and you just sort of accept it. Michael, staying with you, look, we know that it's been signed into law, but what is the status of the Hate Speech Act right now?
Well, the problem with any law, even if it turns out to be, not a good law and is challenged and subsequently overturned, until that point, if it's an act of Parliament, it is in force and enforceable. And so therefore, even though there may be, and almost certainly will be, challenges to this law, and even though it may ultimately be overturned, until that point, that is the situation, that is the status quo. It's interesting, the Equality Act that we've discussed was, I think, passed in 2001, and it had a definition for hate speech in it, which in 2021, when the Kwali judgment came out, was it 21, Liesl, or 23? But anyway.
No, it was 2021, I believe.
Let's say 20 years later, the Constitutional Court said, actually, that definition is unlawful and unconstitutional, but it had been in force and enforceable for nearly 20 years. So that is why these laws, this is why we really advocate that people get involved in the lawmaking process, because once the law's passed, then you're fighting a back game essentially.
Yes.
Then you're already in troubled waters.
So then, am I correct? And this is just me being ignorant, and also hopefully maybe asking this question for some of the people that might be listening in or watching. Is the Hate Speech Act, now that the president signed it, is this now officially law?
Yes.
Okay. All right. So
100%.
there we have it, guys. This is 100% law now. The Hate Speech Bill has been signed into law.
I think the only element of it, I think, that we're waiting is some form of directives as to the police as to how it will be enforced. But again...
Yes, and directives for the MPA, but that does not mean that the operation of the act is suspended. It is in force and it is enforceable.
Correct.
Okay.
Yeah.
All right. Yeah, because I think that's another whole topic on its own, discussing how certain acts that are passed into law, you might need an extra 100,000 people just to enforce this law, and another 2,000 courts across the country in order to process all the cases. But we won't go down that road. Let's start closing up with like maybe the last 3 or 4 questions here, and we'll let you guys go back and forth here. Overarching concerns with the Hate Speech Act, substantive, procedural, and unpacking these details maybe in a few separate questions here. So let's look at top 5 substantive concerns. A, substantive concern 1, criminalization of expression, unnecessary duplication of the SA law, which this is,
yes.
Yeah.
So the mere fact that this act criminalizes speech is problematic because the criminalization of speech is inherently anti-freedom of expression. And when you criminalize speech, because freedom of expression is such a central and fundamental human right, democratic right, or really a hallmark of a healthy democracy, whenever speech is limited, even when you limit it in a civil law context, that limitation must be very narrow. And now it's a criminal law context. This is not a civil law. This is a criminal law. You can end up going to jail, having a criminal record. That has far-reaching implications. So that the mere criminalization of speech is problematic, and we'll get to why we think this is unjustifiable limitation of speech. And then also it's an unnecessary duplication. You don't want too many laws on the books. It's not good for justice in a way.
Yes.
You want to protect people's freedoms and have necessary laws, enough, but not more than that.
Yeah.
We already have a civil hate speech law, the Equality Act. That it's not a criminal law. It has sanctions in the forms of fines, apologies, the right to reply, and it has been used successfully. We even have a criminal law that you can use for hate speech, the common law crime of crime and injuria. It's basically criminal defamation. It was used against Penny Sparrow and Vicky Momberg for hate racist speech. It was used successfully. So we have those laws. But now there's this whole new codification, and it just goes wider than the Constitution. So that's problematic. It really starts making my brain just start jiggling around a little bit. Let's look at a substantive concern number 2. Subjective, and this is a big one for me, subjective, vague, overbroad definition, if you can even call it a definition, of hate speech, which includes wide definition of harm and failure to define hatred, which is, I think, this is why people are scared. Yes, this really is the crux of the matter, is the wide definition of hate speech, because the wider a definition is, the more it captures within it, the more types of speech will fall within its net. And the definition of hate speech has 3 key elements. The first one is harm, because it's harmful speech or speech that incites harm. Now, the definition of harm in this Hate Speech Act is wider than the definition of harm in the Civil Hate Speech Act, in the Equality Act. Okay. So this definition, the criminal definition of harm, includes economic harm. It includes social harm. Now, economic harm should better be dealt with under the common law of delict, or in the criminal sense, you have malicious damage to property. Then social harm is a new concept, and its definition is just, it doesn't really help. It's basically anything that undermines the social cohesion of South Africa. What on earth does that mean? Where does that start? Where does that end? And that's very problematic.
Yeah, that can be really twisted and construed to a person's personal opinion in how they decide they want to express that specific.
Yes, absolutely. And in Kwalani, which is this concerns Papuda, or the Equality Act, they spoke about deep forms of harm, deep emotional, physical, psychological harm. This the Hate Speech Act speaks about substantive. Deep sounds a bit like that's a higher, threshold. The criminal law should have a higher threshold.
Yes.
Then Kwalani speaks about emotional harm, but we're dealing with a civil law. You can't just copy paste between a criminal and civil law. Emotional harm is very subjective. Is that the right thing appropriate for a criminal law? That's an important discussion to have. So that's this vague definition of harm. And what's the problem with you when you have laws that are vague? Open to subjective interpretation, arbitrary application, laws not being applied equally and fairly to all. So that's the first element. The second element is hatred. The short answer is hatred is not defined. So what does hatred mean? And in these days, one person says, I feel that's hatred, but we can't have the subjective standard. In Kwalani, the court gave brilliant definitions coming from international cases and international guidances on international law that we are bound to as a republic. Has guidances that says include a robust definition. The stakeholders in the committee said include a robust definition of hatred. It was not included. We need to define what hatred means. And then the other element of this definition that is very problematic is this also the grounds. That's also, but I think we'll get to that. The wide list of grounds and because that all in together it just makes this definition wide, much wider than the Constitution, and much wider than our civil hate speech law.
Yeah, well, I'm a short guy. I've got short man syndrome, and I don't like people talking down on me.
Hate speech.
So Michael, I don't know. Are you allowed to give examples?
Yeah, I think I can.
Without it being hate speech?
Yes, no, I absolutely can. No, but here's the thing. I was on a radio debate with Deputy Minister John Jeffrey, who obviously leads the department that produced this law.
Yes.
And one of the things that I challenged him on, I said, here you have the definition of hate speech, that it's something as hate speech. And when we talked about the fact that hatred, bizarrely, in the hate crimes and hate speech bill has no definition, but it also catches people if you cause somebody substantial emotional harm. What is that exactly? I mean, what is substantial emotional harm to you? You might be deeply offended. I might not be offended at all.
Correct.
And he actually gave two interesting examples, because he said, there's just so much, people are worrying about things that they shouldn't be worried about. He said, obviously, words can carry a level of weight beyond just the words themselves. And, he mentioned in South Africa, obviously the K word is something which we absolutely, do not say. And that has been shown to be and decided to be hate speech. Fair enough.
Yeah,
because
very
fair. Because that does. It carries an extra weight beyond the actual word. So he said, so if you use that word, then that would almost certainly be... he said, but if, for example, you say that somebody who says that they're a man, but they believe that they are in fact a woman, or vice versa, if you said that actually, no, you're not, or who you say you are, the biological reality is such that it's undeniable, and yes, you may have that level of let's say confusion, but that, he said, that's fine. But is it?
Yes.
Because where does the substantial emotional harm actually impact? It impacts the person.
Correct.
And if I believe that I'm a woman, but I'm actually a man, but I sincerely believe that, and you tell me I'm not, and you won't use my preferred pronouns or whatever it is,
that is going to be substantial.
That is substantial. And
Yes.
if I'm a pastor in a pulpit, and I say, God made them in His image, male and female, He created them. There is no third sex. You're one or the other. Is that offensive to somebody who has that level of confusion about their own, entity? Probably yes, maybe deeply, certainly substantially.
Yeah.
And therefore, is that criminalized? And that's the big problem. He says, well, it's obvious. No, it's not obvious, because the law is always down to the definitions. It says what it says. It's not up to somebody else to say, okay, this is how we're going to interpret it. I mean, ultimately, the courts will start to interpret it. But at the beginning, as we set off today, it's very open-ended, and that's really concerning.
Yeah, it boggles my mind, just this whole subjective thing, because it's like if someone has a personal problem with you and you say something the wrong way, they can take that and twist it and say, no, but I've been hurt by that, and what you've done right now is contravene the Hate Speech Act because of, and you might have not meant it in that way at all. I mean, I'm the type of guy that people often say to me, Vaughan, we could spit in your face and you would literally do nothing about it. You are just that non-fussed about anything. Even if people are derogatory towards you or say anything bad towards you, you're just like, no, that's cool, no problem, I love you anyway. Not everyone is like that. Some people are hypersensitive. So to have everything so subjective, I might just say to Liesl, you're a little bit too white for my liking. You need to go and get some sun. You could take that the wrong way and say, no, but you that was hurtful towards me. Is that able to be taken up now to court according to the Hate Speech Act? If someone takes it the wrong way and says, you've now deeply offended me and hurt me by your comments?
Well, that is the essence of it, substantial emotional harm. So we don't know, in other words. But here's the other thing, which I think really problematic, is that there have been hate speech cases in the recent past where one faith group has brought a case against another faith group because what that faith group has said is very offensive to them. That's problematic. I mean, it's bad enough if it's a civil issue, but if it's now a criminal issue, and particularly because it will now mean that a judge will have to start to sort of almost arbitrate between two different faith viewpoints and two different faith beliefs. And that is so contrary to some of the overarching principles of actually where judges can and cannot or should not intervene from a legal basis. But this has now thrown it into the criminal space. So it's really problematic.
Yes, and there's a famous case in Finland about a lady she was a Finnish member of parliament. She was the Minister of the Interior at some stage. And she's been subject to criminal prosecution, various rounds or levels of courts. She gets acquitted on every level, but then the prosecution appeals it to the next level. She quoted Bible verses. I think more in the context of a church and her views of marriage. And she's been charged with a crime that's in their criminal code is kind of, very close to a war crime. And the prosecution of this offence that she did, it came 10 plus years after she tweeted this tweet, quoting from the Bible. So that's where, you say, nobody's condoning true hate speech. All human beings, whatever their viewpoints, however they identify, whatever they believe or not believe, you have inherent human dignity. We all have equality. We're not arguing that. We all have rights and freedoms. Don't be hateful towards each other, like real hateful. But there's a line. And where do you draw the line? And if you have a law like this, it's so vague, it makes a slippery slope. And the reasonable person in the street's like, we're not going to abuse this law. But there might be a person who wants to kind of weaponize this law.
Correct.
Or groups who want to weaponize this law against other groups. And we don't want that. Because in the end, it's just going to victimize people unnecessarily, put them through the litigation, which is horrible, even if you're vindicated at the end. But it really it impoverishes our democracy. It is not true. It will impoverish diversity because, you might self-censor people. We don't have this robust debate anymore. It's like this kind of, it's very, it paints a bleak picture.
I think the other problem is, the Norwegian case is very interesting because twice she was tried, twice acquitted. I think they're now appealing it, so she's going to be up for a third time. The punishment is in the process. Even if she's not found guilty at the end, which I'm sure she won't be, by the way. But that is when this weaponization is very, very concerning. And unfortunately, when you have a vague law like this, you cannot know when you've crossed the line.
Yes, and I think that brings us to substantive concern number 3, extended list of grounds. Michael?
Well, the people who are protected from hate speech in the Constitution, it's 4 groupings that Liesl's already mentioned. If you look at and you sort of tally it up in the Hate Speech Act, it's 18. So the list of people who are protected gets wider and wider, and some of them are very controversial. Let's say sort of gender expression, sexual orientation. These are very, let's say, uncertain grounds. And once you get a protection, of course, then you can literally go and knock on the door of your local police station if you feel that somebody's substantially hurt your feelings and file a case.
Correct.
And then what will happen? I mean, the other ridiculous thing, of course, is that how much time will this take up from our already overstretched police force, who surely should have far better things to do than to be arresting.
Yeah, and you have to take everyone seriously. You can't say, no, but I'm just dismissing that because it's personal opinion, because you can't do that anymore because the Hate Speech Act says that it's not personal opinion anymore, it's now criminal.
Well, they passed a hate speech law in Scotland about the same time. And I think in the first week there were some 7,500 complaints. Never mind knife stabbing crimes and that sort of thing. Let's go and arrest people for something that they said.
Sure.
Anyway.
So, substantive concern number 4, self-defeating exemption clauses. Liesl?
Yes, I'll get to the exemption clauses. I just want to say on the grounds that under Quilani, sexual orientation was found to be a ground for hate speech under the civil law. So that one at least is not controversial. But the other, long list with novel and contested concepts, people don't even know what the meaning is of this word from this one week to the next. That is problematic and needs attention. So why do we say the exemption clauses are self-defeating? Because they're worded in such a circular way. Now, at least there are exemption clauses. The original version of this bill didn't have any, but there's one for religious expression, for the press and the media, for artistic expression, and for scientific kind of inquiries, etc. But it's worded in such a way that it's like it basically reads that you don't commit hate speech unless you commit hate speech. Only harmful expression is excluded, but expression that causes harm is still included. So why is this problematic? Because the definition harm is still defined very widely. Hatred is not defined. You still have all those grounds. They all come back right in. So we say practically that is not much of a protection.
Getting back to you, Michael, we touched on this a little bit earlier, but the sentences that have gotten more harsh as it's been finalised and then passed into law, is it really necessary to have such harsh sentences for this kind of a thing when it's such a broad and open-ended kind of hate speech act? Like you said, it's going to ruin people's lives.
I think you have to ask the question, to what end? That it went from 3 to 8 and it ended up at 5. 5 years is a long time.
Yeah,
and
especially in a South African prison.
And the question is, how helpful will that actually be in actually preventing hate speech, or even to persuade people that what they're saying perhaps is hateful and they mustn't say it anymore? It doesn't actually fit the crime, so to speak. And you're not going to persuade somebody not to. It's interesting, but speech is actually also a product of thought.
Yes.
So really the most important thing we should be doing is helping to bring harmony in society, rather than punishing people if they step out of line with harsh sentences. If anything, that drives it underground. It separates people still further. It doesn't solve anything at all. It's actually counterproductive. And I think that's probably one of the biggest concerns about this law particularly, and this type of law, is that it actually breaks down societal cohesion. It doesn't improve it.
Yeah. The remedies under the civil, under the Equality Act is much more reconciliatory in nature, which actually would foster true kind of cohesion.
Yes.
Yeah.
So let's look at some other substantive concerns. Substantive concern number 6, overall unconstitutionality. Oh, that is a massive word. Overall unconstitutionality, including criminalizing private communications and non-compliance with international law. I think we'll leave you to do this one, Liesl.
Yes, so the short answer is, why do we say it's unconstitutional? Because it's broader than the prohibition, or it's broader than the definition of hate speech in the Constitution. So the moment you go wider than the Constitution, you're in trouble. The red light should go off.
That is so crazy.
And what is interesting is in Quilani, when the Constitutional Court considered the definition of hate speech under the Equality Act, they specifically said that private communications are not included. The Hate Speech Act does not exclude private communications. So that's a glaring oversight. They could have just written it in there, just make it clear, but it's not there. People have asked, stakeholders asked, please put it in. It was not put in. And then non-compliance with international law. We have international obligations around hate speech, but it does not necessarily require a criminal response. We have international law obligations around protecting freedom of expression and freedom of religion. And guidances on the international law that deals with hate speech and freedom of expression say that the criminalization of speech is a last resort measure in limited, strictly justifiable circumstances. And you need to put a higher threshold. And there's this a rebut plan of action which has a 6-part threshold test. Stakeholders asked, put the rebut test into this act. It's a guide for the court, it's a guide for whoever is investigating, prosecuting this thing, just to have that threshold sufficiently high. It's not there. So for us, that is a glaring oversight.
That's crazy. criminalization of distribution and wide definition of victim. This is another one.
Yes. So it's not only the person who is the original author of communicator, creator of the hate speech. If you distribute hate speech, so for example, if you make a podcast and you say something that is hate speech, and then perhaps you have a person working for you, or a person who listens to your podcast, and they send that on. Or pastors is standing in the pulpit and preaches, and whatever this pastor now says is hate speech, and somebody posts that on social media, shares it to a friend, they're also guilty of hate speech. So it's the liability needs to be curtailed a little bit. And then the wide definition of victim. The definition of victim, who can be a victim of hate speech, quite wide. It's any person, including a juristic person. So it could be a company. And I spoke about economic harm. For example, if people protest a company, a retailer, because they support a specific social cause and they are calling for boycott this retailer, and it's based on one of these grounds, many grounds, is this now hate speech? It's an important question, is it? But it can be a juristic person, it could be a group of persons. And then when they look at the victim impact statements, the impact of the hate speech, because that's also, I think, an important consideration. It doesn't just stop at the victim. It goes much wider. You look at the victim, any kind of like a family member, an associate. It's so incredibly wide. It's not, and you want criminal laws to be kind of narrowly defined, because we're talking about curtailing freedoms and putting people in jail.
Correct.
And the law needs to be clear. It's part of the rule of law. The law needs to be clear. Does the man on the street know what this means? I sit in conversations with other people who are legally trained attorneys, advocates, and they go, well, we think this is what it means, but we can't be sure.
Yeah.
How is the person on the street going to know how to avoid a criminal conviction?
Yeah, it's crazy that, like you said, you can't even go and find a guide that'll give you different stages or steps. Okay, if this was said, did this happen? Did this happen? It's just, for me, it's so vague, and I think that is why so many people are scared. And another concern, lack of parliamentary oversight.
Yes, so the executive, so that will be the Department of Justice, can make regulations under this act. Now, credit to the department, many acts will not specifically say submit the regulations to Parliament. This one does. But if Parliament does not approve these regulations within 60 days, it is deemed approved. And this is a significant criminal law. So could you not have, and often, like Michael has said, sometimes the government, we don't know why, will publish a document for comment on the 15th of December. What if a department, for some reason, quite innocently, but for some reason, publishes a regulation at a stage when Parliament goes into recess, or there's a big constituency period, or now where it's kind of like in limbo? Because the government,
you could almost use this, do this on purpose if you've got an agenda, so that you know that after 60 days, without it being done, without Parliament doing anything, it's automatically just going to go through.
And that's something to keep in mind. I mean, we don't ascribe bad intentions to anybody, but you have to, when you have a law like this, you don't know who's going to come into positions down the line who might want to abuse it. So you need to close those loopholes.
Yeah, correct.
And that is a loophole that is open.
And bear in mind, they could produce the regulations or the guidances now, but they can change them tomorrow.
Yes, correct.
So it's not like once they've said it, that settles it. And that's why these laws are so dangerous, this law particularly, because, again, it is open to weaponization, and it is potentially open to abuse of the democratic process.
Well, I hope this, as much as a scary conversation, I hope it also just wakes people up a little bit to realize that, not that you must be scared about what you must say, but that you need to be more of a public participant and really make your voice heard when these things have not been passed into law yet.
No, 100%. 100%. Again, back to the public participation briefly. Politics is a numbers game. And if enough people speak out,
yes,
then what might be a whisper, if it's just a few people, becomes a shout. And number one, you've got the opportunity of challenging something on the fact that due process was not followed. And number two, politicians aren't stupid. They know that if they do enough things that go against the will of the vast majority of people, bye-bye the next election.
Yes,
so
correct.
It is something which we really want to increasingly encourage people to do, and to support organisations like 4SA. Dare I say it, because we are the ones who are literally the watchmen on the wall.
Yeah.
And when we do lift up a flag and say there's a problem here, that's where we need people to rally, because we have to, I think, increasingly in our democracy engage as citizens in the life and the lawmaking processes of the nation.
And that's why, since looking at your website and seeing the way you package your information into a way where it's not long and drawn out, you can read it and understand and get the gist of what is going on. That is why I think it's so important for people. And this is not a podcast that has been sponsored by 4SA, guys. I'm just saying, if you want a site to go to find out about this kind of stuff, 4sa.org.za is a site you can go to and literally unpack the stuff in a very short space of time and get a sort of basic understanding of what is going on. So with what you've been saying now, Michael, you have sort of addressed a little bit about the dismissal of public concerns, the lack of meaningful public participation, and how that can sway things. What has been your greatest challenge or frustration, especially on the legislative journey of the Hate Speech Act?
I think probably the fact that government simply ignored the viewpoints of the people, very legitimate.
And this was intentional, do you think?
Well, it's hard to say it wasn't if the end result is what we've got.
I just had to throw that out there. Just had to throw that out there.
The proof of the pudding, unfortunately, is in the eating in this instance. But I do not think, and we obviously look at all the submissions that come in from different... I would say the vast majority of civic organisations and public comment were unanimous in their opposition to the vagueness, the open-endedness, the high level of criminalisation and penalty. It was unanimous. It wasn't like it was 50-50. It was like sort of 99.9, yeah. And yet all that was ignored. I think there is a level of frustration because it really was, in a sense, a flouting of the democratic process. Yes. And as a consequence, we're left with something which is really a horror when it comes to a piece of legislation. Probably the most undemocratic piece of legislation that we have yet seen in the new South African dispensation.
Yeah, and this is South Africa with really a really amazing constitution that's really progressive, and to have something that has been passed into law that goes against all of that is just, for me, it's so shocking. So Let's look at this, Michael. What has been the impact of the hate speech laws in other countries? Because you were saying earlier there have been these kinds of laws passed in other countries. What impact? Being abused, being weaponized, especially against persons of faith?
Yeah, we watch this closely. I mean, we often can see overseas it's always worse than we've got here.
Yeah, we can almost use it like a barometer.
The sort of current is coming, or the tide's heading in our direction, if you like. But yes, I mean, for example, in the UK, where I was raised and where I went to university, in Bristol, my law professors back in the day, and we're not talking that long ago, I mean, okay, 40 years, but that's not that long ago, told me that, of course, our rights are protected, freedom of expression, freedom of religion, because we are a Christian nation, quote unquote. Well, lo and behold, not even 35 years later, a pastor in the city of Bristol, perhaps a kilometre from where that statement was made to me, was arrested. Why? Because he dared to say in public, the Bible says, and he quoted a verse, Jesus said, I am the way, the truth, and the life. No man comes to the Father but through me. And there were some people in the crowd who were very unhappy and they didn't agree with him. And the police were called and he was arrested. Wow. And the prosecution, the Crown, the state, in other words, argued that in 21st century Britain, if you quote certain scriptures in public places, that will almost certainly amount to hate speech and be a disturbance of the peace. And he was actually convicted and fined. It was overturned on appeal. But it just goes to show how swiftly things can go south.
Yes.
Another, perhaps even more chilling one, was a woman was standing under a street lamp, not a nefarious purpose. The police walked up to her and said, what are you doing? And they said, are you praying? And she said, well, I might be praying in my head. And she was arrested.
Whoa, thought crimes.
Why? A thought crime, precisely. Because she was in a no prayer zone that had been declared within a certain circumference of an abortion clinic. It just goes to show how draconian and the application of this, the fact that you're putting the forces of the state to stamp out somebody's thoughts
that
are inappropriate. So we can see where this is going, and it's very concerning. But in this country, I think, thank God, we do have a constitution. Thank God we do have a robust legal system where we
Yes.
can actually challenge these things in the courts. And I think that is perhaps the hope that we have going forward, is that even if bad stuff does manage to slip through, or be forced through, perhaps would be a better way of putting this, there is at least redress.
Yes, so I think South Africans were a robust and resilient bunch, and I love that about us. So I
Yes.
think, that gives me hope.
Yes, peaceful robustness, guys. No rioting, looting,
peaceful,
burning down
peaceful.
Parliament again, or anything like that.
Peaceful, robust, and resilient people that uphold the law and the constitutional order.
So Liesl, how can an unconstitutional act, because that's really what this is, how
Yeah.
can an unconstitutional act be challenged? By Parliament, by the President? I'm not too sure about those two, but by the public?
So in part, the President, and that's why we had a petition to the President, and we encourage the public to write to the President, he has the authority to send a bill back to Parliament if he has concerns about its constitutionality. He can also send it to the Constitutional Court. We asked him to exercise those powers. He did not do so. Then the National Assembly may also apply to the Constitutional Court for an order declaring all or part of an act of Parliament unconstitutional. For example, in this act, we have no issue with hate crimes part. We have an issue with the hate speech part. And to the extent that the definition is to why. If you have a robust definition, problem solved, probably. But the National Assembly can do that, but they need to be supported by 1/3 of its members, and they have to do it within 30 days. And that act was signed on the 6th of this month, so they have about a week. They're probably not going to do it, not with all the election excitement, other things on the menu. So Parliament is probably not going to
Coincidental or strategic in signing it just before elections?
We don't know, eh? Might be,
Sure.
might not be. So that leaves it to the public. The public can also challenge the laws, and perhaps Michael can get to. I think that's one of the next questions. The next steps going.
Because
what we can do.
For a lot of people, they think the end is nigh. This is the end, and yes, it is nigh for this podcast. Unfortunately, it's been great chatting to you guys, but we're going to end off with this, Michael. This is not the end. There are always next steps. Litigation. What are the next steps?
Well, we are certainly looking at the opportunities and the grounds upon which we can challenge this, and we think that there are probably three. There's the ground of the fact that not due meaningful public participation process was not followed. The unconstitutionality of this, which we've discussed, the fact that it is far broader in its definition of hate speech than the civil definition. Is actually, crazily enough, easier for you to be put in jail for 5 years than it is for you to be forced to make an apology for what you said. I mean, that gives you an indication of the level of absurdity of this. And of course, the fact that it is also contrary to international binding treaties on South Africa, the way that it's been drafted, and the fact that they did not abide by the rules that they actually are obliged to when they come to define particularly a crime of hate speech. So we're looking at that. I think other organisations are looking at that too. But it's certainly not over. And this law must be challenged. And sooner or later it will be challenged, because sooner or later there will be a hate speech act case, and then everybody will obviously, I think, be joining that case to bring the different perspectives and viewpoints. So one way or another, it's not over, but it is going to be a struggle and a fight, and it is something of an uphill one, but that doesn't mean to say we shouldn't fight it. We absolutely must, because this is something which is about as contrary to democracy as you could possibly get.
Yeah, so it's not over until the fat, thin lady, man, anything in between decides to sing, because we don't want to stand on anyone's toes and offend anyone or be misconstrued as being hateful or speaking hate speech on this podcast. But Michael Liesl, it has been absolutely awesome. And guys, we've been speaking about public participation the entire time here. The way you guys can do a very quick and very engaging public participation is wherever you hear this, wherever you see this, drop what you think in the comments section and let us know, so that we can reply to those comments and we can take them under consideration, and we can see just how much public participation we can garner from these kinds of engaging talks and discussions that we are going to have on these kinds of topics, especially on the Hate Speech Act that has been signed into law right now. So Liesl, Michael, thank you very much. And guys, once again, please go and visit the 4sa.org.za website. Go and see all the information that they've got there. It's a lot of hard work and effort that these guys put in to be servants, so that you guys can have access to something that is understandable and not read a 100,000 page document, if I can embellish it like that, and then try and understand all the legalities that they throw at you. But let's hope that this is not the last, but just the first of many meaningful discussions that we can have. And 4SA are all over the place. Go and find them, follow them on social media. And from Michael and Liesl, I know they are saying goodbye. And from myself, Vaughan, aka the Cyber Hitchhiker, we are saying goodbye for now. And we'll catch you guys on the airwaves, and we'll catch you guys on the other side of the microphone. Cool. Guys, thank you very much for joining us.
Thanks so much.
Thank you so much, Vaughan.